For example, if someone accuses you of wrongdoing in your presence and you do not respond or deny it, your silence might be considered adoptive admission. So essentially it's someone saying, if you say nothing, then you're essentially could be admitting guilt. Wow. What? It's looking like we've got another response from the state here when it comes to some of the issues that Brian Steele, aka Young Thug Jeffrey Williams, were having in this case and throughout this case so far. So we're going to go ahead and get right into it. State of Georgia, Young Thug, aka Jeffrey Williams. And this is a letter to Judge Whitaker. All right, y'all check it out. The state's response in opposition to defendant's motion for correct ruling on adoptive admissions. Let's see what the background is talking about. All right. Despite binding Georgia and persuasive federal precedent authorizing their admission on July 10th, 2024, defendant Young Thug moved this court to vacate correct prior rulings on the introduction of adoptive admissions, under 24-801. Young Thug does not request specific relief on this matter, nor does Williams delineate why this court should eschew binding and persuasive statutory. Okay, we got a lot of big words up in here. We're just going to keep it moving for the regular people like myself. Nonetheless, trial court has correctly ruled on adoptive admissions in this trial in according to Georgia federal rules of evidence. Okay, so we're going to take a quick break right here, and we got to figure out what's going on, because I don't want to go through this whole thing and read it and pretend like I know what adoptive admissions are. Adoptive admissions occur when a person implicitly agrees with or adopts a statement made by someone else, often through their actions or failure to deny the statement when it would be reasonable to do so. This concept is used in legal setting to suggest that the person's silence or behavior indicates their acceptance of the statement as true. Interesting. For example, if someone accuses you of wrongdoing in your presence and you do not respond or deny it, your silence might be considered adoptive admission. So essentially it's someone saying, if you say nothing, then you're essentially could be admitting guilt. Wow. What? Okay, so the state is basically saying that this is their response to opposition to defendant's motion for correct ruling on adoptive admissions. Okay, so now this is making a little bit more sense. We're going to get into it. So, sending Georgia's former ban to their introduction to oblivion, the Supreme Court of Georgia, in accord with federal precedent, approved the introduction of adoptive admission in criminal cases in state versus Orr. The state's briefing argument and this court's order on the introduction of gang lyrics evidence, the concept and application of adoptive admission were delineated in considerable detail. Well, what was the detail? Chief Judge Glanville ordered granting admission of evidence of lyrics at trial November 27, 2023 at page 27, subparagraph M, state's second supplemental motion in Lamine to admit evidence of the lyrical trial. Okay, so I thought they were going to give some explanation, but they didn't. Thanks for nothing, state. The state incorporates that material by reference and provides the following in summary and supplemental response. Rule 801 authorizes the previous court's ruling on the introduction of adoptive admissions and governs a trial court's consideration of the same. I hope they give some examples going out through this. Let's skip ahead a little bit in this, because I want to see some of the examples here. So we'll go. Here we go. Young Thug is partially correct in asserting that mere silence by a party. Okay, so they explain what we just looked up the definition for. Young Thug is partially correct in asserting that mere silence by a party opponent in the presence of another statement standalone does not automatically equate to an adoptive admission. However, A defendant's silence may, in certain circumstances, communicate that he has adopted another person's statement as true. Make that statement admissible under Rule 801. I feel like I was just talking about this type of thing. Oh, man. That is crazy. So basically, if you're talking to your kids and you're going through and you're trying to figure out who took cookies out of the cookie jar, and I say, hey, what were you doing earlier? Oh, I was in the kitchen. Okay, and what were you doing in the kitchen? Were you get some food? You get something to eat? Yeah, I was getting something to eat. Were you near the cookie jar? I mean, yeah, maybe. I might have been, possibly. Did you open the cookie jar? I mean, is that what we're saying? Adoptive admissions are? I mean, if you're a little bit quiet after I ask you, you were in the kitchen, you might have opened the cookie jar. And then I ask you, did you take cookies out of the cookie jar? I mean, and you quiet? I don't know. Some of the attorneys, all the attorneys in the building who are watching, let me know if that is a correct assessment of what adoptive admissions are. And we'll keep it moving. I could be way off, but that's just how I'm reading it. I'm just a regular guy reading some documents. All right. In evaluating whether evidence qualifies as a defendant's adoptive admission under Rule 801, the trial court must find that two criteria are met. Here we go. You got to admit you were in the kitchen, and you got to admit that you were near the cookie jar, is what I'm guessing they're going to say. I haven't read this yet. We'll see. The statement was such that under the circumstances, an innocent defendant would normally be inducted to respond. There are sufficient foundation facts from which the jury could infer that the defendant heard, understood, and acquiesced in the statement. After the initial determination is made by the trial court, the jury is then responsible for making the ultimate determination of whether the defendant adopted the statements as true. I think we're on the right track here, y'all. We're breaking it down. Are we becoming lawyers in real time? I think we're breaking it down. So I say, hey, I saw the light was on in the kitchen. You were in the kitchen. Is that correct? Yeah, I was in the kitchen. You know, there's a cookie jar in the kitchen, right? Mm-hmm. Why were you in the kitchen? I mean, I was a little bit hungry. Okay, well, did you get something to eat in the kitchen? Yes, I got something to eat. What'd you eat? Oh, I don't know. I got something out of the fridge, some oranges, or I don't know. Okay, well, what about cookies? Were you hungry for cookies? Did you want to eat some of the cookies in the cookie jar? I mean, maybe. Were you near the cookie jar? Did you open the lid? I probably could have. So you're telling me that you went into the kitchen, you were hungry, you saw the cookie jar, you opened the lid to the cookie jar. Maybe, who knows? You sat there, you took a whiff of the cookies, you were looking in there, and you're going to tell me that you didn't eat any of the cookies in the cookie jar. Now, the jury sees that, and then I say, no further questions, Your Honor. What are they going to think? They're going to think you ate some cookies. So I don't know, man. I could be totally off. I hope we have tons of attorneys that are tapped into the community and watch the show. Y'all let me know in the comments of this video. Am I way off or am I pretty close? A clear example was found in Wilkins, where the court found it reasonable that a statement referring to a bloody shirt in the trunk of the car that appellant drove up in was standing next to as the shirt. Wait, what? Hold on a second. We got to read this again. A clear example was found in blank, where the court found it was reasonable that a statement referring to a bloody shirt in the trunk of the car that appellant drove up in was standing next to as the shirt. we used to wipe blood and fingerprints off of a gun is the kind of statement that would normally prompt an innocent person to clarify that was part of the. Okay, it's not me. There's a ton of typos in here. It's an innocent person to clarify that the was not part of the we. What? We'll keep it moving. The foregoing said a direct confrontation with the accusatory statement is not always coupled with a lack of denial required for the application of Rule 801. I want to read this Rule 801 too. See, for example, the cases below. This case, holding trial court did not abuse its discretion by admitting statements in a rap video the defendant silently appeared in as an adoptive admission. Like, who, Lord, somebody proofread this. I know we got a paralegal that can proofread this state. Y'all are tripping. Hold no abuse of discretion by the trial court in finding defendant's pre-arrest silence was an adoptive admission when defendant stood silent after being verbally accused of having intercourse with a minor. Hey, yo. Hey, run for your life. Holding statements were properly admitted as adoptive admissions when defendants remained silent in the presence of co-defendants discussion implicating them all in illegal smuggling activity. Okay, so I think we're on the right track, y'all. If what I'm seeing from these cases below are right. So if someone says something and you're silent, the state is saying that you should be able to admit that as adoptive admission. Very interesting. We learned something today. I had never heard of adoptive admission, or I'd never heard it phrased that way before, but that's what we're here to do. We're here to learn. And now we know a little bit more of what it means. In conclusion, the trial court's prior evidentiary rulings on adoptive admission have been in accord with Rule 801D, 2 and B, and case law of the same. Adoptive admissions may be admitted in Georgia criminal trials. Young Thug's motion should be denied. And this also makes me want to find the original motion from Young Thug on this one, because I want to see what Brian Steele is saying the reason that these should not be admitted. So y'all let me know what you think in the comments. Did we give a good assessment? Did y'all learn something today about adoptive admissions? And what do you think that Judge Whitaker is going to do in this one?